prior to the U.S. Supreme Court in the Viking River Cruises case, the rule in California is that a PAGA claim, it can't be divided into an individual and non-individual claims, and that arbitration agreements purporting to waive PAGA claims are unenforceable. So that long-awaited decision by the U.S. Supreme Court held that the Federal Arbitration Act preempts California's rule that prevents a PAGA claim from being divided into individual and non-individual claims. The court also ruled that a wholesale waiver of PAGA are invalid, and ultimately the conclusion by the court was that based on a severability clause in the agreement, that Viking River was entitled to enforce the agreement insofar it mandated arbitration of the plaintiff's individual claims. So what happens to the non-individual PAGA claims under the U.S. Supreme Court's ruling? Basically, under Viking River, once an individual claim is ordered to arbitration, there is no mechanism that allows a court to adjudicate a non-individual, aka a representative, PAGA claim, so that a plaintiff can maintain non-individual PAGA claims in an action only by virtue of also maintaining an individual claim in that action. This means that a plaintiff whose individual claims are compelled to arbitration loses what we call standing to serve as a PAGA plaintiff on behalf of other employees. So we thought, after the long-awaited decision in Viking River, that that was the final word on PAGA, but it is not. It was a matter of weeks after the Viking River decision that the California Supreme Court granted a review in the Adolph versus Uber case. And in the Adolph case, the plaintiff is arguing that the Supreme Court, got it wrong. Once an employee suffers a labor code violation, they are forever an aggrieved employee and have standing to bring a representative case. Importantly, in the U.S. Supreme Court's case, Justice Sotomayor had a concurring opinion, and she had warned about this issue, saying that of course, if this court's understanding of state law is wrong, then it's up to the California courts in an appropriate case to have the last word. So the last word may in fact come from the California Supreme Court in the Adolph case. And again, the case has been briefed, it's been argued. No exact time of when the decision will come down, but it's likely it could come down tomorrow or next week, and I think most definitely sometime this summer. So in Adolph, the issue is whether an aggrieved employee who has been compelled to arbitrate his individual PAGA claims still maintains standing to pursue that representative claim on behalf of other similar employees.